Good afternoon, everybody. Welcome to the University of Salford. My name's Phil Brown. I'm a Professor of Social Change embedded within the Social Work Directorate here, but don't tell anyone I'm not actually a social worker. But I'm also Research Centre Director for the School of Nursing, Midwifery, Social Work and Social Sciences. And we're really proud of being able to reinstigate the Making Research Count seminar series at the university after a short hiatus of a few years. And we're able to use this forum to try and engage in a really meaningful way with some of the work that's going on within the university, but also crucially engage with other professionals and other researchers and academics across the UK in order to provide evidence and knowledge back to the people that need to use that kind of work in their daily policy making and practice. So that's many of you here today as well. Making Research Count, not sure how many people are familiar with Making Research Count, but it's a national initiative. There are a number of universities involved in Making Research Count across the UK, including York, and Keele, and King's College, and a variety of other universities. We're the regional hub, if you like, for Greater Manchester, and we're trying to work more around the integrated services approach, where we're looking at trying to bring particularly social work, theory and practice and knowledge together with other disciplines, particularly health and housing, to understand how best to integrate services to provide support and information around the most vulnerable and to join professions together more effectively. So essentially, in that sense, we're acting as a knowledge broker, really. The idea really is to bring people together for dialogue and discussion. So that's what we're really trying to encourage today. So please engage freely with the speakers that are here today as well. This is here fundamentally to support the learning needs of organisations out there, outside of these walls. So in that sense, we're led very much by the kinds of issues that are important to you as practitioners and as people out there away from the university. So what we're trying to do is have a dialogue with different organisations about what it is that you want to know more about, what you need to know more about, both now and in the future, in order to prepare organisations for and provide that sort of resilience. So that's pretty much my introduction to Making Research Count over. I want to hand over to the chair of the day, which is going to be Jameel Hadi, who will take you through the rest of the format. But just to say welcome, and hope you enjoy this afternoon, and thanks for coming. And again, thanks to our speakers for taking their time to talk about their work.
Thanks, Phil. Yeah, hi, I'm Jameel. I want to echo what Phil said about welcoming our visitors here today. If you take the metaphor of a stage and an audience, the most important people here aren't on the stage, they're in the audience. And that's where the research comes from, and that's where we want the ideas to generate the ideas from your experience, and also to hopefully stimulate your thinking about the ways you work with people, because that connection's fundamental to things like Making Research Count, I believe. I'm lucky enough to be chairing this, and I suppose it's because I've got a connection in some way with all three speakers. I used to work in youth justice for 10 years, over 10 years. The reason I became a social worker was I wanted to keep young people out of custody. It was as simple as that for me. That's exactly why I became a social worker. It got more complicated after that, but that's how I started off. And I read this book, and when I finished social work in 2003, I'd increasingly been spending more time with young people who were being sent to custody. And one of the places I visited was Stoke Heath. And one of the tragedies of a young man who hung himself, who grew up not very far from here in Sale, was a young person called Joseph Scholes. And the book documents his death in custody. He was a great lad, but he had a lot of issues. He was a very vulnerable young man. And at the time, I was visiting young people from Liverpool in custody, and I was challenging the prison about the way they were treating young people in custody, because I felt the culture was rotten compared to when I visited other places. And as a result of my efforts, I was invariably the last person allowed in on the official visits, and I was the last person allowed out. And I was given a really hard time. So when Joseph died, it stuck in my head, and I contacted the Youth Justice Board, because we know that cultures that allow or collude or turn a blind eye to things, that's where things go wrong, because people don't speak out. So in vain, really, I tried to speak to someone in the Youth Justice Board and said, do you realise this is a really rotten culture? That's probably why it happened. I kept him in my mind, and then when I read this book, I thought, I'm not in the habit of emailing authors, but it affected me so powerfully, and I was so pleased that someone was telling me how it is about the institutional abuse that takes place in children's prisons. But I contacted Carolyne, who very kindly got straight back to me and said something like, "You've made my day." And at that point, I then thought of another old friend and colleague and tutor of mine, Barry Goldson, who, although he doesn't remember this, I first met Barry in 1992 when he was a practitioner, and to me he's always been someone who's an academic but who's written about practice for the benefit of people who work. And I can remember in our youth justice team in Liverpool that we actually would read what academics like Barry wrote about, and we would go to conferences that they organised, and we would engage with those debates. And that was very important. And at the time, Barry, I can remember at the first meeting, would boast that he worked in a custody-free zone of St Helens, and he's confirmed that today, that it in fact was a custody-free zone. So there were parts of the country in 1992 where young people did not go to prison. So I kind of contacted Barry, and I kind of returned. One of the reasons I ended up as a lecturer partly is that I actually returned to education, and he became my tutor and my supervisor in relation to a piece of research I carried out. So I immediately contacted Barry and persuaded him to come here. Barry's the chair, Barry's the editor of the journal Youth Justice and has written very widely, but again, he's concerned with the impact that his ideas and his learning has on practice. And then the third connection really here is Ian Cummins, who's a lecturer in the university, who's constantly trying to popularise academic thought. He writes extensively for an online publication called Conversation, where again what stands out for Ian, I think, is his willingness and enthusiasm to make a connection with people struggling with issues or struggling with these roles in practice, right? So we're very lucky to have the three speakers we've got here today. Just a couple of things before I introduce Carolyne. Donna will be in charge of tweeting around this, and we'll be using the hashtag MRC Salford in our tweets. And Donna is producing or compiling this into something called a periscope, right? So stay tuned for that. And the format of this is we're going to hear from the three main speakers, we're then going to break, and then we really welcome contributions from the floor. We want to understand what's happening and what people's views out there are. We are filming this, but we are only filming the three presentations. So don't be worried, you will not be captured on film. So we're just going to film the initial part of it. So welcome everyone. Really pleased it could all come, and I'd like to introduce Carolyne Willow, please.
I've got notes today because there's so much that I could say, that what tends to happen is I get drawn into one particular area that outrages me, and then it's 40 minutes before I know it. So please bear with me for having notes. Barry and I were just talking that we've never tweeted. I have done PowerPoints before, but I don't know. Right, so Okay. Firstly, just to start off, Happy Human Rights Day, everybody. Why did not work? Sorry, am I doing the same thing? Same mistakes again. That's a good theme that's going to be going through. It's this one.
Yeah, it's the arrow.
Sorry. Okay. 67 years ago today, the United Nations passed the Universal Declaration of Human Rights. And there's a particular section in that declaration that entitles motherhood and children, and I've just taken off children here today, to special care and protection. So happy Human Rights Day. 2 years ago, the then Education Secretary Michael Gove delivered a lecture at the NSPCC about taking action to protect children. He warned of the perils of succumbing to the rule of optimism. How many social workers have we got in here today? We all know of the rule of optimism, or we've heard of the rule of optimism. Michael Gove said children, who are always our first concern, can be left at risk and in danger when we need to intervene to rescue them from an abusive environment, just as determinedly as we would seek to rescue them from any scene of any natural disaster. The rule of optimism, which Gove alluded to, was coined around 30 years ago by researchers undertaking a study on child abuse and neglect cases. Although it is commonly used to castigate individual social workers for being sloppy and naive, it was actually a sociological term to describe what they called the liberal compromise, that the family will be held open for inspection, provided that the state undertakes to make the best of what its agents find. And the researchers pointed out that there must be overwhelming evidence before a family can be said to be abusive or neglectful. I propose today that the rule of optimism allows us to tolerate the intolerable in child prisons. Robert Dingwall and colleagues observed two devices maintaining the rule of optimism in work with families. The first is cultural relativism. Professionals have an elastic expectations and different standards for different types of parents, families and communities. The second device is to invest in the notion of natural parental love. And both these devices, they argue, function to neutralise state intervention. And they also help social workers to hold on to their ideals while surrounded by suffering and hardship. Ofsted analysed 147 serious case reviews carried out between 2009 and 2010. You will know that serious case reviews are meant to be undertaken when a child dies and abuse or neglect has been suspected, or when there has been serious harm. One of the frequent lessons from these 147 serious case reviews was that workers were too often held captive by the rule of optimism. Ofsted concluded that this led workers to focus on adult strengths, rationalise evidence to the contrary, and interpret data in the light of this optimistic view. Child protection no longer sits with Michael Gove's portfolio. Though as Justice Secretary, he is responsible for around 1,981, to be precise, of the country's most vulnerable children. That is, children who are sent to prison to be punished or remanded to prison to be punished whilst waiting to be punished. Child prisons have become more transparent in the past decade or so, following the horrific deaths of two boys, Gareth Myatt and Adam Rickwood, who we will return to later. But the political and financial investment in child prisons remains undented. Why? First, a little about the backgrounds and experiences of children prior to entering custody. 1/3 of boys and 6 in every 10 girls have been in care. This means they have been physically abused, sexually abused, emotionally abused, neglected, abandoned, or suffered all of those violations. Research by the Youth Justice Board on 180 children serving long custodial service sentences found 42% had been looked after or adopted. 23% had been in care before the age of 11. The rate of material deprivation, poverty, among children in custody is 4 times higher than in the general child population. This means these children have gone without. They have been cold, hungry, poorly clothed, they have missed out on opportunities on school outings, they have grown up in areas of disadvantage, and they have probably felt ashamed and humiliated by their circumstances. We know that children from black and minority ethnic communities and disabled children are nearly twice as likely to live in poverty as other children. The majority of children in custody will have been excluded from school. Whatever the reason for this, the exclusion process will have probably compounded the child's feelings of being no good and an outsider. A significant proportion of children in custody are disabled, with many having poor cognitive abilities, limited literacy, and profound mental health difficulties. We must face the fact that imprisoned children, in all likelihood, will have grown up with an awareness, whether passive or profound, that other children in their street, their school, and in wider society will have had much more than them, and not just materially much more. There is also the heartbreaking statistic that children in custody are 3 times more likely than other children to have suffered the death of a parent and or a sibling. The majority of children in custody are held in young offender institutions where physical and mental violence, fear and intimidation, hunger, isolation and sensory deprivation are as predictable as daily roll checks. To steal a title from Leonard Cohen, everybody knows about the suffering of children in prison. Check out the inspection reports, the research reports, investigations by the Prisons and Probation Ombudsman, the verdict of inquest juries, legal judgments, the notes left behind by desperately unhappy children. You might expect children's rights campaigners like me to be accused of using hyperbole. The truth is, I'm increasingly lost for words. Take the most recent published inspection report concerning Cookham Wood in Kent. Isn't there in May 2015, inspectors found children were being strip searched under restraint. 3 boys had been taken to hospital after restraint, and 1 boy was kicked in the calf by an officer using his heel, after the boy had refused to leave the room where staff had been conducting his ACT review. ACT is an acronym for Assessment, Care in Custody and Teamwork. It's the prison services self-harm and suicide prevention programme. This boy didn't want to leave the room in which people had been discussing his struggles, his difficulties. 1 in 5 children are held in secure training centres where, despite continuing revelations of mistreatment, they are kept in superior environments than those sent to young offender institutions. Children are better educated, for example, and they are allowed to eat at dining tables rather than in locked cells. Just 11% of children sent to custody are placed by the Youth Justice Board in secure children's homes. Secure children's homes are governed by the same legislation as ordinary children's homes, and they have higher staff-to-child ratios. One secure children's home is run by a charity, the rest are run by local authorities as part of their children's services. Although children may experience living in a secure children's home as being imprisoned, they are not designed or legally defined as places of imprisonment. If cultural relativism and a trenchant belief in natural parental love help those working in the child protection system with families to remain optimistic, what devices are employed to make child incarceration bearable? Having spent many years researching, campaigning and trying to understand child prisons, I'd say cultural relativism is central to the maintenance of child prisons. And then I would replace a belief in natural parental love with what we might call the Boxer device. Boxer, you will recall, was the loyal, hard-working cart horse in George Orwell's Animal Farm. His motto was, "I will work harder." No matter what was thrown at him, he never relinquished his faith, first in Mr. Jones and then in animalism. Boxer could work with whatever programme his masters threw at him, just like prison administrators who, despite devastating evidence to the contrary, never relinquished their faith in incarceration. If you want to see what I mean, take a look at the press releases issued by the Ministry of Justice and the Youth Justice Board whenever Nick Hardwick, the Chief Inspector of Prisons, releases yet another scathing inspection report. We are working on it, the constant broken record plays. Back to cultural relativism, and it's not only the hallowed status of prisons that alters our perceptions of what is tolerable and intolerable, it's also the reputations of the children that are sent there. These are the children banished from our communities because they are seen to be bad, out of control, a threat to society. With reputations as tarnished as theirs, child prisoners who shout out abuse are typically reliant on CCTV evidence to back them up, a standard of proof not expected of any child sleeping in their own bed at night. What information would you ordinarily require in order to decide whether a child's nose that has been broken by an adult has suffered physical abuse? Here's a summary of an incident occurring about 5 years ago. The boy complained about an incident during which a nose distraction technique had been used. This had led to his nose being broken. The child said he had been misbehaving with others during an education session, and 3 officers had asked him to return to his cell. The officers accompanied him, one on either side and one behind. The child alleged that one of the members of staff prodded him in the back several times. He said that when he turned to protest, one officer held his nose and face, pushing his head to the floor, while the other held his arms and legs. The child described this as an extremely painful experience. You might be thinking, the boy was misbehaving. 3 officers were required to escort him back to his cell. This must have been a violent incident. It wasn't actually. The Prisons and Probation Ombudsman that investigated this incident said there was no violent struggle prior to the injury, and this child had no history of ever being violent in prison. The child's complaint was only partially upheld because the PPO could not be certain whether the use of force had been justified. The document does not say whether a local authority child protection inquiry came to a different conclusion or whether one was even undertaken. Take a more recent incident. The Prisons Inspectorate released a report 3 weeks ago about the new system of behaviour management and restraint called Minimising and Managing Physical Restraint, MMPR for short. This report gives an account of a prison officer trying to subvert the debriefing process, where the child's version of events is meant to be obtained and recorded. We only have the debriefing process because it was one of the 34 recommendations in response to the death of Gareth Myatt. 34 recommendations made by the coroner following his inquest. A child recently told the prisons inspectorate when asked if the debrief process had helped him, as it's meant to do on paper. The child said, "No. In the incident, they said I hit a female member of staff. The person who came to see me said, 'Say you did it and I'll go away.' I wouldn't because I didn't. He stayed for over half an hour because I wouldn't give in. He said, 'You are taking the piss out of my time.' I asked if I could see the CTB because I knew that I didn't do it, but he said that I couldn't. He eventually wrote, 'refused to admit,' and that would be in the report that then goes to Whitehall. Cultural relativism allows for behaviour that will be unacceptable in one context to be accepted in another. In community settings, this might be a health visitor who becomes accustomed to seeing infants with red raw bottoms from soiled nappies. A teacher who sees nothing exceptional in a child coming to school with an empty stomach. Or a social worker who interprets cold formality between a child and an adult as a legitimate expression of respect for elders. Narratives exist about what individual families, streets, neighbourhoods and whole communities are like, and these affect how events are interpreted and the level of intervention deemed legitimate. Cultural relativism allows us to tolerate the intolerable in child prisons. Out of a crowded field, I have selected 3 practices. Confining children in locked cells for protracted periods, emotional abuse and neglect. The infliction of pain as a form of restraint, physical abuse. And forcing children to remove their clothes or removing their clothes by force, sexual abuse. Prison cells are typically 5.5 square metres, what would be called a box bedroom in a family home. The Youth Justice Board and the Prisons Inspectorate expect children to be out of their cells for 10 hours a day. That would leave children confined in a poorly ventilated, artificially lit and sparsely furnished space for 14 hours, with shouting, swearing and heavy doors slamming constantly in the background, every day. The Youth Justice Board further requires the prison service to allow each child 30 minutes of fresh air a day. You might be thinking 10 hours outside of a cell and 30 minutes outside is not asking for much. The latest inspection reports, which are in your handout, indicate that only one prison park in Wales met this standard. In fact, its unlocked time was 10 hours, 30 minutes during the week. At weekends, this dipped to 9 hours, though this was nearly double the time of Feltham in London, which provide children with 4 hours, 35 minutes unlocked time. Ian will speak later about the detention of children in custody in police cells. Surely it is cultural relativism that enables us to condemn the detention of distressed and poorly children in police cells, but not in prison cells. In July this year, the Chief Inspector of Prisons told us over a quarter of boys reported having spent a night in segregation unit, where conditions remained mostly poor. Some remained in segregation for too long, 133 days in one case at Cookham Wood. At Feltham, special accommodation, an empty cell in other words, had been used several times with no clear or justifiable reasons for its use recorded. A child held in isolation for 133 days. To get this into perspective, if you were to be put in isolation tomorrow, 133 days would take you to the 22nd of April 2016. Research recently published by the Office of Children's Commissioner for England gives a child's account of what isolation feels like. It was a lot of emotions going through my head at once, really. I was upset, angry. I've gone from being out of my pad all day to being isolated, well, locked up really, for 3 days straight. So there was a lot of emotions going through my head. I didn't really know what was going on. I was up and down. I was angry, smashing up my pad and stuff like that. I ended up tying something around my neck and dropped to the ground. This child would have been punished, by the way, for smashing up his pad. So children in young offender institutions are banged up in their cells as a matter of routine because that's what happens in prisons. Then unlock time is further reduced when there aren't enough staff or because the child has lost privileges or they are too frightened to come out of their cell. This protracted isolation occurs in the main parts of the prison as well as in segregation, where special cells are also used. A special cell is an empty cell. Children can be placed in special cells because they are being violent or refractory, also because they are very ill. In March 2002, 16-year-old Joseph Scholes died in scandalous conditions in a young offender institution in Shropshire. His mother, Yvonne Bailey, told me, "I was told he was put in a safe cell." So again, it's this use of language. They should have said, "Yvonne, he's in a cell. He's stripped naked. He's got a horse blanket-like garment on, fastened with Velcro. It's filthy and squalid. I mean, the window's about 2 or 3 inches deep in dirt between the pane and the bars and the outer pane. He's on a concrete plinth with a thin plastic mat." That would have been the truth. But instead, I was told he would come to no harm. He's in a safe cell. He's in safe clothing. 9 days after he was admitted to prison, a maintenance worker found Joseph hanging from the bars of his cell window. Joseph left a letter to his parents, which included this apology: "I'm sorry, I just can't cope." Fast forward 10 years to a prison in Wigan. Jake Hadi, aged 17, was another extremely vulnerable boy. In December 2011, he was remanded to prison, his first time in custody. Jake had special educational needs, ADHD, and had self-harmed before he entered prison and whilst incarcerated. He chose to spend most of his time in his cell because he was relentlessly bullied by other boys, as he had been as a younger child in the community. Jake hanged himself in January 2012, and he left behind a note for his mum. "Mum, they kept giving me shit. I told the staff and they did nothing about the problem. So Mum, if you're reading this, I'm not alive because I cannot cope in prison. People keep giving me shit, even staff." Jake's mum told me, "When I gave my son, who was a child at the time, to the prison, you expect them to be looked after, not pampered, to be looked after, to keep them safe, warm and fed. That's all you expect." The UN Special Rapporteur on Torture and Other Cruel, Inhumane or Degrading Treatment or Punishment concluded in 2011 that the imposition of solitary confinement of any duration on juveniles is cruel, inhumane or degrading treatment, which violates the UN Treaty Against Torture. The rapporteurs definition of solitary confinement is being isolated in a cell for between 22 and 24 hours. It's the same definition for adults and children. Whilst not wishing to underestimate the anguish caused to adult prisoners, I believe we need a distinct, much shorter definition for children, if they're to be confined at all. Research for the Children's Commissioner found the average duration of solitary confinement in 4 young offender institutions was 7 days, 5.5 days, 9 days, and 12 days. Once a child is in solitary confinement and comes out, that doesn't mean that box has been ticked and they can never be returned again. In fact, segregation units are full of the same children that keep returning. The data from the Children's Commissioner's Office was for June 2014 to December 2014, not 50 or 100 years ago. Why do we tolerate the intolerable? As we saw earlier with the boy who had the nose broken, there is another penal practice that would be unconscionable in any other children's setting. That is the deliberate infliction of severe pain as a form of restraint. This practice would not even be in the public domain were it not for the death of a 14-year-old boy, Adam Rickwood. Adam hanged himself in August 2004 after being unlawfully restrained in Hassickfield Secure Training Centre in Durham. Serco ran that prison until January 2015. You may have taken in that the Goddard inquiry has decided that one of its first 12 investigations will be on prisons and other custodial institutions, and it will make a special investigation into Medhamsley Detention Centre, which was on the same site as Hassickfield until the late 80s. More than 1,200 former inmates of Medhamsley have reported sexual abuse and physical abuse to Durham Police. Adam was subject to the nose distraction. He left behind a note asking what gave staff the right to hit a child in the nose. As I say in my book, Adam's mum, Carolyne Willow, had to go all the way to the High Court to get an honest answer to her son's question. There was no such right to hurt a child in these circumstances, said Mr. Justice Blake. In 2005, I visited Hassickfield as part of the independent inquiry into physical restraint, solitary confinement, and forcible strip searching in child prisons conducted by Lord Carlisle. We were shown a form on which the centre recorded restraint. I asked what the column headed distractions referred to and was shocked when the centre manager told me this was the space in which staff recorded the use of the nose, rib and thumb distractions. These are prison service techniques which involve fingers being pushed into the nostrils and the nose being yanked back, digging fingers and knuckles into the child's ribs and yanking back the child's thumb. To be lawful, these could be used only in extremely grave situations. I was working at the Children's Rights Alliance for England at the time, and we made a Freedom of Information request for data on their use. We discovered that in 2004-05, a period of 1 year across 4 secure training centres, the nose, rib and thumb distractions were used 768 times, resulting in 51 recorded injuries. Extreme methods used routinely. More than 3 years after Adam's death in December 2007, ministers suspended the use of the nose distraction in secure training centres, and it was permanently withdrawn a year later after a delegation of anti-torture experts from the Council of Europe condemned the practice. The nose control, same technique, different name, persisted in young offender institutions until 2010 or 11. but was replaced by the mandibular angle technique, which involves a severe swipe to the nose. An exchange of arms, you might say, not an amnesty. The mandibular angle technique is part of the MMPR system, which was introduced into Rainsbrook in April 2013 and is now being used by all 3 secure training centres and 3 of the 5 young offender institutions. 1/3 of the restraint techniques in this new system rely on the infliction of severe pain. We cannot assess for ourselves how these work because the document describing the techniques has 182 redactions, blacked out. This means children and families and children's social workers cannot be provided with information about the individual restraint methods, and the secrecy surrounding the techniques inevitably impedes the child protection and safeguarding functions of social workers, independent reviewing officers, complaints investigators, independent advocates, and local safeguarding children boards. How can child protection and safeguarding professionals work out whether a child has been restrained using an authorised technique if they're not allowed to know what has been authorised? How do we know whether that officer who kicked the child in his calf with his heel was using an authorised technique or that he'd made it up himself? My case for disclosure of the MMPR techniques will be heard by the upper tribunal in February next year. The first tier tribunal supported the Information Commissioner's decision that not to order disclosure because it threatened the security of child and adult prisons. The decisive reason for this, the tribunal said, were the similarities between the techniques in the MMPR system and the techniques used in adult prisons. You will know that MMPR is branded and promoted by government as being especially designed for children. 3 weeks ago, the Prisons Inspectorate reported that officers in young offender institutions commonly inflict pain, including through the mandibular angle technique, the swipe to the neck, in breach of policy and therefore the law. They don't refer to the law, I'm just telling you, if it's not used in grave situations, it's unlawful. Restraint policy, the Inspectorate says, agreed by ministers, states that staff should only use pain as a last resort to prevent an immediate risk of serious physical harm. But we found that pain-inducing techniques were used frequently in young offender institutions and that in most cases staff were not compliant with the requirement. Almost 10 years ago, the Carolyne report concluded pain compliance and the infliction of pain is not acceptable and may be unlawful. In 2008, the Parliamentary Joint Committee on Human Rights declared there can be no justification for restraint practices which involve the deliberate infliction of pain, and we therefore recommend their abolition without delay. In 2009, the European Torture Committee recommended the UK discontinue the use in juvenile establishments of manual restraint based upon pain-compliant methods. In 2013, the UN Committee Against Torture, there ain't no higher body, recommended the UK ban the use of any technique designed to inflict pain on children. Earlier this year, the 4 Children's Commissioners of the UK, in their submission to the UN Committee on the Rights of the Child, stated pain should never be deliberately inflicted in order to restrain a child. The common framework used by all of these bodies is human rights. Human rights treaties protect all children in all circumstances. How would prisons manage without being able to inflict pain on children? Whitehall officials may ask, although they probably would use different words. The obvious retort is that nose distractions were endemic in secure training centres before Adam Rickwood blew the whistle. The other point is that secure children's homes, which also detain children sent by the criminal courts, are not allowed to use such techniques. They're explicitly prohibited. Then the officials might take a look at other settings and other countries which manage to look after children without routinely inflicting severe pain. They might also consider how wayward children were treated in the past in this country. They don't have to wait for the Goddard inquiry to report in 2020 or some later date. They can take a look at the opening page of the inquiry report into the abuse of children in children's homes in Leicestershire. The hell started on the day I walked into the place. I had just left home and was naturally upset. I was quiet and tearful. Although I must have been there for a long time, it just seemed like minutes later that they got hold of me, accusing me of chucking out angry feelings, of hating my mother and sisters. When I tried to explain that I missed my mother, they trapped me between their legs and dug their fingers into my ribs and made me scream and cry out in pain. That sounds to me like the rib distraction. They could also take a look at the Social Services Inspectorate investigation into the use of prison service restraint techniques in Aycliffe in Durham. That report is dated 1993. Cultural relativism was another device employed to defend the routine strip searching of children after the same demeaning practice was banned for female prisoners. We start a bit later. Do you want me to? Am I okay? Yeah. When Lord Carlisle recommended the end of routine strip searching in 2006, the response was that this would endanger the security of prisons. The Youth Justice Board only started collecting data on strip searching in 2011. Through a Freedom of Information request, I found out that in less than 2 years, there were 43,000 strip searches of children in young offender institutions and secure training centres. And 50 of these searches were undertaken using force to remove the child's clothes. If you are not sure what strip searching entails, here's a recent account from a child. When they got me to the special cell, they asked me to take my clothes off. I said I would, though I did say in an aggressive attitude, but you would, as you're not going to respond nicely to a question like that. Anyway, I would have taken them off. They took me straight to the floor before I had a chance to do it myself. Someone put a knee on my back, which did hurt a lot. They took my shirt off completely, then my trousers, boxers and shoes. They chucked a jumper on me to cover my bum. You'll see the date there, 2015. One of the chapters in my book is titled I Think It's Quite Like Rape, which was a statement made by a girl during research for the Youth Justice Board. In the book, I write, as well as words like rape and sexual abuse, children reported during the YJB review that strip searching made them feel humiliated, embarrassed, intimidated, paranoid, dirty, strange, stressed, vulnerable, scared, violated, and weird. I heard similar words when I was a child protection social worker interviewing children about sexual abuse. Those children also told me about threats. It is clear that strip searching provokes the same devastating feelings among children as other forms of sexual abuse. When I interviewed John Drew, the former chief exec of the Youth Justice Board, I asked him about strip searching. He told me about the opposition he faced at the highest level of the prison service. When he tried to advocate change, he was made to feel like a do-gooder who had no idea of how to run a prison. By the way, if you're wondering what was found through those 43,000 strip searches of vulnerable children, I can tell you that no knives, explosives or guns, these are recorded by the prison service, were found. And the single most form of contraband was tobacco. Disproportionate is an understatement. That children are no longer automatically forced to remove their clothes on admission, on discharge, when they go to court, when they enter segregation. Yes, being stripped naked was once a routine part of being taken to the block, and at other random times might be held up as proof of progress. Look, things really are getting better. Inspectors now have often comment positively on the absence of routine strip searching, but they invariably highlight the lack of paperwork and therefore accountability when children's clothes are removed, supposedly after a risk assessment. Their strong and repeated recommendation that children must never be strip searched under restraint lie on the page unanswered. As well as being experienced as a form of sexual abuse, we must contemplate the way in which strip searching has facilitated other forms of sexual abuse in the past and perhaps still today. If you're thinking this is alarmist, take a look at the National Crime Agency's report on institutional child sexual abuse, published in the wake of the Savile revelations. There are plenty of civil servants who have devoted years, decades, to the task of humanising child prisons. There seems to be no limit to the optimism in the face of constant criticism and harm. If they were social workers working with families, we'd expect their managers to be kindly but robustly saying, "We have done enough for this family, the harm must stop." Take the number of times 30 hours of education has been promised on paper. The earliest Youth Justice Board pledge that I can find is from 2001. If this was a set of parents that had failed each successive year to get their child to school, who had failed repeatedly to provide a stimulating environment, or worse, had taken to locking their children in their rooms day and night, whether as punishment, out of necessity or ignorance, how patient would we want social workers to be? Similarly, I have lost count of the number of reviews the Youth Justice Board has commissioned on restraint. As we approach the 12th anniversary of 15-year-old Gareth Myatt being bent over in a seated position by 3 G4S officers until he became lifeless, children still tell inspectors they cannot breathe during restraint. Moreover, in its recent review of the new MMPR system, the Prisons Inspectorate found a minority of staff who don't believe children when they say they cannot breathe, reminiscent of Gareth, who told officers he couldn't breathe. During this latest review, a member of staff told the inspectorate, "Kids sometimes just say stuff so that you let them go, like they can't breathe, but you know that they're having you on." And a child said, "I couldn't breathe. It felt like someone had their hands around my throat. I was telling staff that I couldn't breathe, but they weren't listening. I didn't pass out on this occasion, but I have passed out in the past." Almost finished. I obtained the report of serious incidents and warning signs for 2013-14, which contained a particularly chilling case. The case of a child who needed his inhaler whilst being restrained. The child was given his inhaler but still restrained whilst taking his inhaler. He vomited. This appears to be one of the 2 cases of asthmatic children appearing to lose consciousness during restraint that year, and one of 4 incidents which involved children vomiting during restraint, just as Gareth had. In all, there were 26 recorded instances of children having breathing difficulties. The report notes that the incidents which caused most concern were those that were not captured by CCTV. The Prisons Inspectorate found that children are on the floor in 70% of restraint incidents in young offender institutions. This poses serious medical risk and is against all training and instruction. These continuing threats to children's lives and well-being are not freak accidents, rogue waves in an unusually calm storm or calm ocean. Prisons are meant to be full of danger, to degrade the individual, to be places of terror. In July, a 15-year-old boy was found dead in his cell in Cookham in Kent. He was the 34th child to die in prison since the UK signed a convention with the United Nations promising to only ever detain children as a measure of last resort. There has never been a public inquiry into any child death in prison, even when requested by the coroner, as was the case with Joseph Scholes. Of the 16 children who died in prison between 2000 and 2012, the Youth Justice reports at least 69% had been subject to care orders, the highest form of protection we offer to vulnerable children. In July, when the latest death was announced, the Youth Justice Board reported, "The cause of death will be formally determined by inquest, but at the present time, we have no indication that a young person took their life or that the circumstances were suspicious." I looked up the word suspicious in the dictionary, and it says it is having a belief or an idea that something is questionable or wrong. Questionable, wrong. Being suspicious is exactly the right response to hearing a child has died alone in a prison cell. We should all be suspicious about everything that occurs behind the high walls of prisons. And then we should set aside any residual optimism that this archaic system of organised punishment can be fixed if only we work harder. It cannot be fixed. We must stop the intolerable. My final question is this: will our Justice Secretary, who has made a series of progressive decisions elsewhere in the criminal justice system, have the courage to rescue the 1,000 or so children from the abusive environments made and maintained by the state itself? I hope we can all make the same strong message. Enough is enough.
Thank you, Caroline. These are kind of routine, everyday events that take place in young offender institutions. Caroline quite rightly calls children's prisons. We forget that sometimes. I noticed the Howard League this week have announced that Hounslow Safeguarding Board are meeting Felton YOI tomorrow to talk about incidents going on in that institution. Before I came here today, I was quite conscious of the publicity in the last couple of weeks about the drops in the number of young people in custody and of first-time offenders in the system. And I was trying to explain this situation to some students today in the Youth Justice lecture, and I'm glad Barry's here because I know Barry's going to deal with why the population of children varies over time and place, which will give us some way of understanding this in a broader way. So, welcome Barry Goldson.
Well, I suppose first thing is thanks to Jameel and to Aileen for all the work they've done into organising this event and bringing us together, and thanks indeed for the kind invitation to join an old friend. She's not old, I'm old. An old friend, Carolyne Willow, who we first met, Caroline reminded me 21 years ago, when we were both doing some work with the National Children's Bureau. And it's great to share a platform, so to speak. What I want to do actually is just attempt to address 3 questions. What do we know about child imprisonment? Well, Carolyne has just given us a very moving and powerful insight into our knowledge. And we've known for a long time, and I'll come back to that point in a moment, we've known for a long time what goes on within prisons and all the custodial institutions in which children are held. So I want to pose the question, set against that knowledge base, why do we continue? Why is the practices of child imprisonment, why are they so stubbornly enduring? And then I want to come to the third question, which Jameel's just referred to, which is why do child prison populations vary over space and time? Broadly, but basically, I would say, with some level of confidence, in the post-war period, youth crime within any jurisdiction, but let's just take England and Wales, because that's where we are, has more or less flatlined. It's more or less stable. And yet the patterns of incarceration go up and down. There is no real relationship between either the incidence or indeed the severity of youth crime on the one hand and the size of the child prison population on the other. So I just want to interrogate that question a little at the end of my talk. Where to start? Well, I want to start with any students of anyone with an interest in punishment and imprisonment will know the brilliant work of Michel Foucault, a French social theorist, French social scientist, who wrote what is an amazing book published in 1977 entitled Discipline and Punish, The Birth of the Prison. And in that book, Foucault made the observation that prison is dangerous when it is not useless. And it's an observation that when I first read that book, it made a very powerful impression on me. And in a way, it captures in about how many words? 1, 2, 3, 4, 5, 6, 7, 8 words what Carolyne has just spent 45 minutes articulating and what I'm going to be adding to, I think. And this isn't something that Foucault had kind of said off the top of his head. There's a very long history of the child prison, dating back to the early 19th century. The first penal institution specifically for children was opened at Parkhurst Prison for boys in 1838. And from then until now, Carolyne touched upon this, we call the institutions different things. But the child prison has been stubbornly enduring. We've moved through reformatories, industrial schools, approved schools, remand centres, borstalls, detention centres, community housed education, youth custody centres, young offender institutions, secure training centres, and detention and training centres. And it's a history that's not only long, but it's also a very dark history. As I noted in an essay I wrote published some 13 years ago now, incarcerative institutions for children are not new, nor are the scandals, abuses, failings and miseries that are routinely produced and reproduced within their walls, through their operational practices. Indeed, the history of institutional experimentation and child incarceration is a history of political expedience, constant invention, reinvention, and cosmetic reform. I want to come back to that point in a little while. Human suffering, the nature that Carolyne has so articulately expressed, and quite spectacular incompetence when measured in terms of its own claims to restore and rehabilitate its young charges. This is precisely the dangerousness and the uselessness to which Foucault referred. So how am I going to address the 3 questions? What do we know about child imprisonment? Why do we imprison children? Why do prison populations vary over time and place? I want to do it in 2 parts. Firstly, and this, I felt a bit uncomfortable about this because it kind of feels a bit self-indulgent, but I'm going to go with it anyway. I want to talk about some of my own work over the last 15 years or so, and how that work has shaped the way I've come to think about these questions. And then in the second part, I'll address the why do we imprison children, and why do the populations move across time and place rather more explicitly. I want to start the story with this report. It was a report entitled Tough Justice that was commissioned by the Children's Society and which I wrote with a colleague, Eleanor Peters, and it published in 2000, almost exactly 15 years ago. I'm starting the story at that point because that is the year that the Youth Justice Board, the agency to which Carolyne is referred, formally adopted responsibility for effectively managing and placing children within the rather euphemistically called juvenile secure estate. And in this report, Eleanor and I made the observation that not only is the physical infrastructure strained and totally unsuited to guaranteeing basic standards of safety, I've just heard about that this afternoon, but the everyday realities are underpinned by a culture of discomfort, anxiety, bullying and intimidation. Such adverse conditions for children and young people, again a point that Carolyne's made, would simply not be tolerated in any other settings. And yet they are prevalent in prison. They're normal in prisons. They're not exceptions. They're kind of deeply embedded within the operational regimes of incarcerative institutions. Now, in 2000, as I said, the YJB assumed responsibility for the juvenile secure estate. And one of the things it did was establish a placements team. This is a team of professionals who were responsible for making, once the courts have made decisions to lock up a child, it was the YJB's responsibility to determine the most appropriate or the least inappropriate place for that child to be held. And the rhetoric that was used around the placements team all centred the question of vulnerability. So the rhetoric went that the most vulnerable children would be placed in local authority secure children's homes and secure training centres, and the children who were deemed to be least vulnerable would be placed in young offender institutions, for all intents and purposes institutions that are exactly like any adult prison. I was intrigued by this notion of vulnerability and how these judgments would be made, and so was the Children's Society. So they provided some funding for a piece of research that ultimately expressed itself in a book entitled Vulnerable Inside. It was quite a long and detailed piece of research. I undertook 111 in-depth interviews with children, young people who had experience of having been locked up. In fact, they were serving prisoners when I interviewed them, and the staff who worked with them. And I'm going to share something with you today which has troubled me and continues to trouble me from the time it occurred to the present. And those of you who might be working in higher education will be familiar with the thorny question of research ethics. The short version of the story goes something like this. There was one institution I was particularly keen to enter because it had received a fair bit of negative attention. And surprise, surprise, it wasn't terribly easy to negotiate access. They weren't desperately keen to let me in there to talk to young people being held. But nonetheless, I did eventually negotiate access. And it was quite funny because the governor who I was liaising with said, look, we're overcrowded, we're understaffed, and I'm principally concerned about your safety, my safety. Of course, I said, well, look, I'm prepared to sign anything you like, which will exonerate you from any responsibility, and to conduct the interviews in such a way that it causes least disruption to the staff and indeed to the children being held. So he said the only way we could accommodate your research request is if you were prepared to undertake the interviews on a Saturday and Sunday, and I think he probably thought, well, that'll put him off, there's no way of coming. But I said, well, that'll be absolutely fine, thank you. And I arrived at this institution one Saturday morning to be greeted by the duty governor, who said, look, I need to tell you, we had a very serious incident last night. A child had been found hanging in his cell, and he's been taken to the local infirmary where he's currently being kept alive with the assistance of a ventilator. And that was the question of research ethics, because at that point, of course, I said to the governor, well, in such circumstances, it doesn't feel appropriate for me to continue with the interviews. And he said, quite on the contrary, he said, we've discussed this and we think it might be beneficial to some of the young people to actually have someone out with the prison to talk to. And then, of course, I retorted, well, I'm here as a researcher, not as a counsellor. But I thought about it, and whether I made the right or the wrong decision, I decided to proceed with the interviews. Literally the day after a child had been found hanging in his cell. And I interviewed a 16-year-old boy who had this to say. He said, last night this kid, I don't know why, I think I was getting bullied, but I don't know. One of the officers opened this kid's door and he just shouted, get the nurse, and we were all put behind our doors. No one knew what was going on, but we all knew, if you see what I mean. We heard them all rushing around, and I reckon we all knew. I knew. I thought about it all night. I couldn't stop thinking about it. This morning when we came out for breakfast, the screw said that he'd tried to kill himself, and he was in hospital on a life support machine. At dinner they said he was dead. He was 16. The same age as me. Everyone was very quiet. So I'd literally interviewed this boy, a 16-year-old lad, within hours of him receiving the news of the death. And that has remained with me very, very vividly from that time on. What it did as a human being is that it confirmed the view that I've held for some time, that no civilised society will subject children to prison incarceration. And I'm a committed abolitionist, and I'll come back to that point in a few moments. What it did to me as a researcher, in as much as you can divorce a human being from a researcher, is that it made me curious about deaths in custody. And I opened a dialogue with an organisation, Inquest, some of you may know about it. It's some absolutely brilliant work in relation to controversial deaths, not just in prisons, but in police custody and psychiatric institutions. And Inquest found a little bit of funding, and I undertook a sustained piece of research on deaths in custody, which eventually published in the form of a book that was published in 2005, entitled In the Care of the State. A claim that we make in the book, and I think I stand by it, that the book comprised the first detailed and sustained analysis of child deaths in penal custody ever to be published in the UK. And as far as we are aware, this is myself and Deborah Coles, one of the directors of the inquest. There are no similar accounts available anywhere else in the world. At that point, Carolyne's made the point that since 1990, 34 children have lost their lives in prison. In 2005, the figure was 28. And what, again, Carolyne's touched upon this. One of the many things that intrigued me, having written and undertaken the research and written the book, and I actually sat through Joseph Scholes' inquest as part of the research, and I met the parents of Adam and Gareth that Carolyne has spoken to. Beautiful people, actually. Point that might be made about Gareth Myatt. Carolyne told the story that he lost his life as a consequence of asphyxiation, having been restrained by 3 burly adult prison officers, secure training centre officers. Gareth was less than 5 foot tall. He was 7 stone in weight. He was a little boy. And I think those kind of details are the details that get lost within official discourse. But one of the things that intrigued me is that there has never been a public inquiry. 28 children, 34 children, and not a single public inquiry. And what we were doing in the book is not just pushing for a public inquiry in relation to any one of those 28 children. We were suggesting that public inquiry should take 28 children in entirety and look at the commonalities. What is it that what conditions are created that ultimately proved to be fatal? The book launched in the House of Commons. There were some very important and influential people at the launch, but to this day the government and subsequent governments have been absolutely steadfast in not wanting a public inquiry, because if the public inquiry genuinely was comprehensive in nature and looked at the 34 child deaths, it would unearth some very troubling questions for people who prefer those questions to remain concealed, I suspect. Anyway, not only was there not a public inquiry in 2005, but round about that time, child imprisonment in the UK, in England and Wales, was reaching a high point. And the next offering was this book, Youth, Crime and Justice, where my long-time research collaborator and very dear friend John Munsey and I pulled together a team of people to try and interrogate, by using the most authoritative evidence and knowledge, to try and interrogate policy questions in relation to juvenile justice. And I wrote an essay in that book on penal custody, which I entitled Intolerance, Irrationality and Indifference, and made this observation. A new punitiveness is consolidated within the youth justice system in England and Wales, most graphically illustrated by a sharp rise in the numbers of child prisoners, developments in law and policy serving to detain increasing numbers of children in custodial institutions, negate a wealth of research evidence and practice experience, illuminating the counterproductive outcomes of penal custody as a measure of youth crime prevention. And in a sense, the new punitive represents penological irrationality. Furthermore, and arguably more importantly, deliberate penal expansion is not only inattentive to outcome evidence, it also disregards the harm and damage that is routinely encountered by children in custodial institutions. It displays a curious indifference to children's suffering, in other words. The sun is shining in Manchester, and that is optimism for you. Now, when we did that book, we also became intrigued by unevenness. So, custodial populations have reached a high mark, a high point in England and Wales, but in other jurisdictions, they were far less inclined to lock up children than we are in England. And also, these patterns change over time, and we became interested in that So the very same year, a companion volume to Youth, Crime and Justice entitled Comparative Youth Justice published that John and I again pulled together a team of people, and in our concluding essay in that book entitled States of Transition, Convergence and Diversity in International Youth Justice, we make the point that some jurisdictions appear to manage their youth justice policies and practices without the level of recourse to penal custody that are to be found in England and Wales. And we, 3 years later, John and I pulled together a 3-volume set within the SAGE major work series. It was a pretty big project, 11 parts over the 3 books, over 1,000 pages, 51 essays from leading authorities from around the world. And we specifically focused on this temporal and spatial comparative analysis. Why is it that over time within a jurisdiction and between jurisdictions, the level of child imprisonments vary very, very significantly? Youth, Crime and Justice made its a return in 2015, and I've particularly, and I'm going to say a bit more about this in a moment, particularly turned my attention to what I call the circular motions of penal politics within England and Wales. Why is it that our readiness or otherwise to lock up children changes over periods of time? So that's the story for now. And Carolyne was asking about this before, and Jameel, I'm currently writing a book at late, finding it difficult to find time to attend to it, entitled Reimagining Juvenile Justice. And one aspect of that book takes me back to a paper that I wrote 10 years or so ago under the title Child Imprisonment, A Case for Abolition. What I'm trying to do with this book is to place the abolition of child imprisonment within a context that would require us to rethink or to reimagine, as the title of the book implies, not just imprisonment, but the way in which a civilized society might address children's transgressions without resort to punishment and the deliberate imposition of pain. Now, I'm going to take, I've got no idea when I started talking, but 20 minutes or so. Yeah? Okay. A quick digression about abolition. I mean, I teach courses at the university just the other end of the M62 here in Liverpool, in which prison abolition is a key component, and Katie, one of my PhD students here, has done those courses, so she'll have no doubt heard me say this before. And you talk to students about abolition, and they look at you as if you're mad. And if you were to talk to people and, wander off now to Manchester and say, what do you think about prison abolition? We think it's a good idea. We'd think you were nuts. But it does no harm just to think, to cast our minds back across history. There was a time when to talk about the abolition of public executions, people would think we're crazy. We can't possibly abolish executions, otherwise, the fabric of society would collapse. It's only the deterrence of the ultimate prospect of losing your life that maintains the social order. That would be the kind of logic. Or if we were to imagine at some stage in history the abolition of slavery, people would think this is just absurd. How can we possibly imagine social ordering? How can we possibly imagine the world without the transatlantic slave trade? And yet now, of course, we reflect, and slavery is still not being abolished, I hasten to add, but we think of slavery as an obscene and deeply problematic moment in our history. was a time when imagining the right to women to vote. This is within the last 100 years. You know, how could you possibly? What would happen to democracy if we gave women the right to vote? My God, you know what? This would really seriously unsettle patriarchal relations to such an extent that we can't possibly allow it. But now to deny women the right to vote offends our sensibilities. And if we were to imagine space travel at one time, people would seriously think we were nuts. Can you imagine a human being walking around the moon? You think, my God, you're mad. But this is now quite routine. So I suppose what I'm trying to say here is that I'm seeing that it's not a rhetorical gesture about thinking about the abolition of child imprisonment. I'm serious about it, just in the way that some social phenomena from the past might have felt impossible at the time, and now these are kind of embedded features of our respective societies. So, to my questions, what do we know about child imprisonment? Well, we've heard a lot about child imprisonment. We know it's had a very long history. It's not an aberration. It's not something that's just happened overnight. However, it's badged, whether it's a reformatory, an industrial school, a young offender institution, or whatever. And wherever and whenever we care to look, the prison comprises ultimately a repository for detaining a constituency of the most distressed and disadvantaged children and young people. That applies right across the world. The prison is ultimately an institutional site that generates the production and reproduction of damage, abuse, in the way that Carolyne articulated, and harm, and the harm is ultimately fatal, as we're aware in the cases of 34 children who paid the ultimate price of imprisonment. And we also know, a rather unfortunate expression that's used in penology, the stock and flow of child imprisonment varies over space and time, both between jurisdictions, nation states, and also within them. We also know that child imprisonment fails the public interest. If the public interest is taken to comprise a society without crime, then the prison is a spectacularly ineffective way of securing that. And I won't go through each of these, but we're all very familiar with the data. Very significant numbers of children once discharged from prison are back in trouble with the criminal justice system within less than a year. It's a failing institution. Again, what I often say to my students, let's just take that top one, 84%. The percentages vary depending upon who's publishing them, but let's just take the top one, 84% now. If you think of any other public institution, if 84% of children were leaving school unable to read and write, we'd be asking questions. If 84% of children were being discharged from hospital less well than they were when they entered, we'd be asking questions. Or to use a different analogy, if 84% of aircraft hit the deck as soon as they took off, we'd be asking quite serious questions about the engineering of the aircraft and stuff. But we can have this catastrophic failures with prisoners, and yet it doesn't seem to provoke those same kind of questions. The other point I want to make, and I think you touched upon this, Carolyne, is that we also know that penal institutions are beyond reform. I love the book Jerome Miller's book, Last One Over the Wall, one of the best books I've read in my life. And Jerry Miller makes the point that reformers come and reformers go, penal institutions carry on. Nothing in their history suggests that they can sustain reform, no matter what money, staff and programs are pumped into them. The same crises that have plagued them for 150 years continue to intrude today. Though the cast may change, says Jerry, the players go on producing failure. And my final slide, just on the question of what we know, is that we also know that the prison represents a means of transmitting the deliberate and calculated imposition of pain. Dan Gunn was a prison governor, and he has this to say: prisons collect children who find it difficult to cope, they collect excessive numbers of children with mental disorder, they collect children who have weak social supports, they collect children who by any objective tests do not have rosy prospects. This collection of children is humiliated and stigmatised, again, Carolyne made these points very well, by the processes of arrest, police inquiry and court appearance. Child prisoners suffer the ultimate ignominy of banishment to an uncongenial institution. It's often overcrowded, the friends cannot be chosen, and physical conditions are Spartan. Above all, they are, by the very process, separated from everything that's familiar to them, including all of their social supports and loved ones, however unsatisfactory they may be. And this is the key point. This is what is supposed to happen. This is what the punishment of prison is all about. It's not an accident. It is deliberate, it's calculated. Prisons are there to make life for prisoners unpleasant, to say the least. So in the face of that evidence, or in the face of that knowledge, it's not unreasonable to ask the second question. Or to put it another way, if child imprisonment is both useless and dangerous, to refer back to where I started with Foucault, why does it endure? Why are children imprisoned? Now I want to put to you the key to understanding this rests with three aspects of politics rather than penology. The first I'm referring to as a political process, the second as a political symbol, and the third as a political choice. Let's just turn very briefly to each in turn. Child imprisonment first as a political process. David Garland, very eminent social scientist, currently working out at New York University, makes the point that it's very much a political process. It's governed not by any criminological logic, but instead by political actors and the exigencies, political calculations and short-term interests that provide their motivations. In its detailed configuration, argues Garland, with all its incoherence and contradictions, it is thus a product of a decidedly aleatory history of political manoeuvres and calculations. Child imprisonment in general, and child imprisonment in particular, is also, it carries enormous symbolic purchase or political symbolism. So an observation I make here, in this sense, an almost totemic status is described whereby the state of youth is taken to signify the moral well-being or otherwise of wider social relations, a barometer, if you will, signalling the composure or agitation, the equilibrium or instability of the social order. And if you think about it, I don't have time to prosecute this much further, but if you think about it, young people are taken somehow as to represent the health of a society. And when young people transgress, or when they commit offences, it carries enormous political purchase. It has to be fixed, so the logic goes. Otherwise, it reflects a very ugly image back to us as a society, and somehow unsettles social ordering. And thirdly, and perhaps most significantly, in answering the question, why do we imprison these children, comes the answer: because we choose to. Child imprisonment is a political choice. Politicians, as I've argued, state policymakers, are not obliged to incarcerate children in penal custody. This is not preordained. They choose to do so. Moreover, they exercise that choice in the knowledge that child incarceration is irrational and spectacularly counterproductive when measured in terms of crime prevention and community safety in the way that we've just seen, and that it succeeds only in imposing harm and ultimately death. So, to the third question, why do child prison populations vary over space and time? tonight, way over. You're being a very accommodating chair, Jameel. Normally you get kind of these notices, don't you? Like 1 minute, stop talking, you've said enough, and all of that stuff. Okay, I'll be as quick as possible here. The first point to make in addressing this question is that child prison populations operate quite independently from youth crime rates. I made this point before. Youth crime is more or less flatlines over time. Child prison populations on the graph go at something like this. So punishment and penal measures, both to refer to David Garland, a more recent essay, are to a considerable degree independent of crime. The sociological insight here is that neither individual crimes nor aggregate crime rates determine the nature and extent of penal measures. It is not crime that dictates penal laws, penal sentences and penal policies, but the ways in which crime is socially perceived and problematized. And this is the significant point. And the political and administrative decisions to which those perceptions give rise. The processes, if you will, the symbols, the choices to which I've just referred, and I'll return to that point by way of concluding in a moment or two. So, if we think of comparative analysis across space first, this is just some selected data. You can see in the most significant column is this column, the rate of children incarcerated per 100,000 of the population. You can see at 13.2 up at the top, England and Wales, and down at the bottom, the Scandinavian states, the Nordic states, Norway and Sweden, at the very bottom, Japan. To put this another way, children are 130 times more likely to be incarcerated in England than they are in Japan. And the explanation for that is not to be found in crime rates. If we move from spatial, the comparative analysis across space, to the temporal, comparative analysis across time, let's just think of one jurisdiction, which is England and Wales. If we begin the story here in 1992, that left column, you can see how child imprisonment reached a peak in 2002. I can tell you why that was, because the government announced a street crime initiative, which cost Joseph Scholes his life, incidentally. It dipped a bit, and then it raised again in 2008, this point here, and then from 2008 we've seen this staggering falling off of child imprisonment. I'm thanking Damon Briggs, who's a PhD student of mine, who should be credited with putting this table together, this diagram together. If I was to run youth crime through that, we'd have, as I say, this flat line over the period 92 to the present. And that makes the point very well, I think. The imprisonment rates operate independently from the incidence and nature of youth crime itself. To put this another way, this is where my notion of circular motions comes in. If we just take the last 30 years or so, period 1, 1982 to 92, was a period of penal contraction. Period 2, 93 to the year of James Bulger's murder, of course, through to 2007-8 is a period of very significant penal expansion. And then period 3, the one that we're currently residing within, is from 2008, and who knows when this will change again, where the penal politics will make its next turn. But this is a period of very significant penal contraction. So I'm conscious now, I'm really rattling, need to speed up and rattle through this. 1980. 7,400 children and young people locked up within over the 12 months. So this is kids who will serve more than one sentence in the year, of course. By 1990, that figure is reduced to 1,400. Or to put it another way, 12% of all children sentenced in magistrates, in youth courts and Crown courts went straight to prison. By 1990 the figure had dropped to 7. Why should that be so? Well, David Faulkner, who was a very senior civil servant, helps us to understand why it's so. The guiding principle of much of the policy in relation to juvenile offenders was one of the minimum use of custody. In conversation later we might want to reflect upon why that is. I don't think I should get into that just here in view of the time. My second period then, 93 to 2008, just look at the data yourself. In 1993, the juvenile prison population stood at 1,300. You see an almost year-by-year increase to the point where in 2008 the figure was 3,072. This is at June 30 of each year. So the number of children being imprisoned in 2008 was just under 3 times higher than it had been in 1993. So we've got a 100% plus increase in child imprisonment, and why would that is that so? Well, the Youth Justice Board made the observation that greater use of penal custody for children is being made in England and Wales than in most other industrialised democratic countries in the world. It's a political choice, point to which I'll return. The period from 2008 onwards then, we see this quite staggering falling off of the numbers of children in prison. So we start with 3,072, and the figure in August, it was 971. By any test, this is very, very statistically significant. And again, we might want to talk about why that should be so later, but just to give you a clue. An essay that published in the second edition of Youth Crime and Justice, I make the observation the global financial crisis of 2008 triggered a discernible shift in political mood. We all know it, we're living the consequences of it in different ways. In this way, it's no coincidence the latest reductionist turn has been and remains framed within a context of deep cuts in public expenditure and conditions that we've learned to call austerity. Whatever other influences are at play, therefore, it seems likely, so my argument goes, that it's the instrumental imperative of cost reduction, as distinct from any intrinsic priorities of progressive reform, that ultimately provide the key to comprehending the substantial fall in child imprisonment in the post-2008 period. I have 2 slides left, Jameel, and I'll be fast. And this illustrates the point. Since 2009, the year after the financial crisis, the YJB has, and this is a statement, so this is not my language, it's the YJB's language, has delivered savings of £287 million at approximately 55% of its overall budget, reducing its budget from 516 to 229 million. And of course the young people in custody has fallen from 3,200 to 971, and this reduction boasts the YJB. This reduction has helped the YJB deliver its savings targets. So to conclude, by returning, as I said I would, to the question of child prison populations operating independently of youth crime, my submission to you this afternoon is that the ebbs and flows of child imprisonment are ultimately best understood as adaptations and responses to political pressures rather than reactions to the incidence and nature of youth crime. In other words, the circular motions of penal politics, the politicisation or depoliticisation of youth crime, high rates or low rates of child imprisonment, the extent to which the penal state might translate or not translate political pressures into specific penal outcomes, are ultimately driven by ulterior motives that are situated beyond the immediate governance and regulation of youth crime itself. And in this way, that rates of child imprisonment are contingent, is subject to the vagaries of social, economic and political conditions. Or to put it another way, just to try and couple up our talks to you, we might want to say that rates of deliberate child violation and child abuse are contingent, subject to the vagaries of social economic. And therein rests my case for abolition. I think we should stop there.
For now, I'm just going to hand over to Ian Cummins, who's going to look at where often a child's journey in relation to prison begins, and that's in police custody.
Thank you, Jameel. Thank you very much for coming. I'm one of the lecturers in the social work department here, but prior to moving into the crazy world of academia, I was a mental health social worker in Manchester, and I was a probation officer. So I guess you have to see everything I'm going to say through the prism of that, what's the word? Misery, I think is the word. I was thinking, the two things I was thinking about before I came here today, one was how Jameel was going to link me with the eminent people who were coming. I was worried what Jameel was going to say about me, but anyway, we'll just go with that. And the other was the link between the work that I'm interested in, the work I've done, and Carolyne's fantastic book and Barry's excellent work that he's talked about. And the real question that I think links what I'm going to say with the two previous presentations is how do we decide, so how do we review children? Who are children? Now that sounds like a very straightforward question, but hopefully I'll demonstrate to you that it's not. And then, once we've decided, when do we become concerned about children, and when do we stop being concerned about them and we see them as a threat? So, those two things. And I must thank Harvey Stark, student of mine, for coming back. I once gave a lecture at another institution.
Wouldn't miss it for the world here.
Exactly. I've not paid him. The students had a break, and the statistician in me noticed there were 50 students, and only 6 came back. So my retention rate has improved. Okay. The main legislation, 2 pieces of legislation I'm going to look at are the Police and Criminal Evidence Act and the Mental Health Act. The police, in this context, it's very, very important to remember what are the roots of this legislation. What are the roots of the Police and Criminal Evidence Act? The Police and Criminal Evidence Act, PACE, comes from a miscarriage of justice. It comes from the murder of a man called Maxwell Comfey in London in 1972. 3 youths were convicted of his murder. One of them had a learning disability. Those convictions were overturned because essentially were based on confessions that were obtained under duress. And out of that came the Police and Criminal Evidence Act. So the roots of these protections for children come from violence from the state. The Police and Criminal Evidence Act was introduced in 1986. It establishes codes of practice about your right to legal advice, taping of interviews and so on. And clearly, for those of us who were around, which obviously the majority of us, the 70s were a very different period to the 1980s in terms of criminal justice, but also just on the technological front. They were able to record interviews and so on. It also created the role of the appropriate adult. I'm sure there's people in the room who've acted as appropriate adults on many occasions. The role of the appropriate adult was created to offer additional protections to 3 groups of people. Juveniles, all juveniles, and we'll come on to the question of who is a juvenile in a moment. Adults with mental health problems, and adults with a learning disability. The role of the appropriate adult in the code of practice and in legislation is to facilitate the interview. There's a very nice sounding phrase around police interview. It almost gives the impression that you're meant to organise the room and make sure there's tea and biscuits and this sort of thing. It's not to represent the young person or the person with a mental health problem. It's very much around ensuring that due process is followed, that the interview is conducted in a fair way, and so on. Pierpoint, who's Harriet Pierpoint, research into the role of the appropriate adult, and what she found was that once, like a lot of legislation, like a lot of penal policy, once this role was established, there were different developments around it. So appropriate adults were seen to be offering welfare advice, they were seen to be offering support to young people and adults with mental health problems or learning difficulties in a custody situation. It's very important, appropriate adults don't enjoy legal privilege. The most famous case, of course, is Janet Leach's, when she didn't represent, but made that fatal error when she was the appropriate adult for Fred West, and was a witness at Rosemary West's trial. Obviously, that is such an extreme case that it kind of defies all other, really. But there are ongoing debates about the nature and effectiveness of the role of the appropriate adult. I came at this from a mental health perspective, and one of the it's an area that's not greatly researched, which makes it attractive to academics. But also, one of the things that immediately springs, you find out immediately, sorry, is that there are very few adults who are interviewed with an appropriate adult present, which means two things. One is that the police arrests a very unusual cross-section of the population, because actually mental health problems are very common, and learning disability is much more common than previously accepted. And then something happens, because we know the figures vary, but approximately about 90% or more, depending on how you define mental health problem, prisoners have some form of mental health problem. So in one setting, there's a group of people who don't have mental health problems, in another they do. So there's some disconnect here. Okay. Carolyne and Barry have both very eloquently outlined that the environment, the custodial environment itself is a risk. And that's particularly increased for young people, juveniles, but also for people who have mental health problems or learning disabilities. There's the physical environment, there's the lack of resources. So the police, I've done work with the police. If the police identify somebody having a mental health problem, they actually have very limited resources to deal with that in a number of settings. So being in custody is itself a risk factor. That increases if people are facing charges for particular crimes, so people charged with serious violence, people who are facing charges related to child pornography, child sex offences, the risk of self-harm and suicide are much higher in those groups. But also, we have to think about that environment in itself, in that any one of us being placed in an environment would find that, I would suggest, a threat to our personhood, and would therefore, for the police, from a police perspective, if you're the custody sergeant, assessing the risks involved is very, very difficult. So, for example, I did some work with the Greater Manchester Police following a death in custody of a man who they knew extremely well. And to them, they didn't see him as a risk because they knew him, they were familiar with him, but on any measure, he was at the highest level of risk because A, he was a middle-aged man with long-standing mental health, drug and alcohol problems, he was in custody, and so on. But so you can see there is a kind of cultural disconnect there. If you look at this, the issues of miscarriages of justice, one of the overwhelming features of those is that there is somebody who has made a confession or is involved in some way who has a mental health problem. It's a recurrent feature from very, very high profile cases like Judith Ward, like Barry George, to less well known ones. And specifically, people with mental health problems have the risk of being drawn into the criminal justice system and not having their needs met. I've done a bit of research locally with around self-harm in custody, and some of these incidents involved juveniles. And I looked at a study, I looked at 168 incidents of self-harm, and what I found was the most common methods of self-harm, people attempting to make a ligature, or simply heading or punching a wall, which quite difficult for the police to stop in some ways. And women were at greater risk. In this survey that I did, 25% of the incidents involved women in custody. Now, the police in this period arrested over 40,000 people. 25% of them weren't women. You know, the figures are very disproportionate. But of course, you then need to look at that and think, well, what are the backgrounds? What are the issues in why women come into the criminal justice system? And similarly to the arguments Carolyne was putting forward, these are the most vulnerable women with histories of being subjected to sexual violence and so on. So if you just look at the rates, they're disproportionate, but you then need to think you're not comparing like with like. Similarly with suicides in prison. Police officers receive very little training in mental health issues. The average training is around an hour, which usually is to tell them about Section 136 of the Mental Health Act. And there's very poor systems for sharing information. So as a social worker, I dealt with an incident where a man had attempted to hang himself in custody. He'd recently been detained under the Mental Health Act, and I'd actually carried out the assessment. And he was living in a hostel. The only time he was discharged, released on bail by the police, and turned up at the hostel and asked him why he had a huge mark around his neck, and he explained, and he would be the most at risk, so immediately fortunately I was able to arrange him to be assessed under the Mental Health Act. But it's one of these areas, as I think Barry and Carolyne were saying, that actually we know quite a lot about this. We know what these causes, what these factors are, but actually how do we respond? Coming on to the issue of young people in the criminal justice system, in terms of the Police and Criminal Evidence Act, up until very recently, essentially juveniles were 17-year-old and under 17. So there has been this confusion around who is an adult, who is a child, and how should we respond. And it's interesting relating to Barry's presentation that these are political decisions, aren't they? England and Wales has one of the lowest age of criminal responsibilities in Europe. We have different attitudes to children. We don't actually like children as a society. I wasn't talking about my own son there, but it's possible to, if there's a child in a restaurant, whatever, they're just irritating, aren't they? Sorry, this is my own misery coming out here. But you need to look at the wider society. You need to look at issues of inequality. You need to look at welfare provision in its broadest sense, in terms of education and so on. In 2011, Her Majesty's Inspector of Constabulary, the only place in the criminal justice system that a 17-year-old is treated as an adult is in a police station. So, up until relatively recently, 17-year-olds were not being treated as though they were children within that setting. So if you're arrested, you're 17, you're treated as an adult. And one of the impacts, and very important impacts of that, is that parents and carers were not being informed of their detention. The police arrested 2011, I think that's last year, sorry, approximately 75,000 17-year-olds. So this is not a small number of a group within the wider system that we're talking about. And the police custody is unique, not only social but legal context. So clearly you have adults interacting with children, you have adults in positions of authority, and this is one of the most important parts of this, looking at these protections, is that if we assume that 17-year-olds or even 18-year-olds are mature adults making decisions and so on, then within the police custody environment, there's different pressures on them. Okay, so if you look at adolescents, their reasoning, they focus on short-term rather than long-term. Clearly in the custody environment, your short-term interest is to get out of that environment. And Kemp's work found that the number of requests for legal advice dropped off rapidly with 17-year-olds. Clearly, the implication being that if a parent or an appropriate adult was involved, one of the most basic things, one of the most important things you can do as an appropriate adult is ensure that somebody has legal representation. 17-year-olds are being asked, do you want a solicitor? No, I'll get out of here. The other factor to consider there is that the impact of what might be seen as minor offences, and are minor offences, they may have much broader implications in terms of your work, career, job, and so on. So there's a danger that we assume that 17-year-olds are much more mature than they are simply because they're in this setting. And in the broader, Barry was referred to the broader international perspective. I think one of the changes, one of the pressures you'll see is that there's particularly in the US, an area that I'm very interested in, there's this idea that juveniles should be treated as adults in sentencing, and the justification for that is that they've committed adult offences. So in certain states in America, Florida and Texas, for example, the court can decide whether a juvenile should be tried as an adult. And one of the ways that they seem to make that decision is because if you were charged with a serious offence, you must be an adult, which is actually a preposterous way of reasoning. But the impacts of that are that those juveniles face life imprisonment. So Florida, for example, has imprisoned 15-year-olds for life without parole. Okay. There's still a child at 17 was a campaign following 3 tragic cases which highlight the implications of 17-year-olds being treated as adults in custody. All of them happened locally, actually. Edward Thorburn was arrested for possession of a small amount of cannabis and committed suicide after his discharge. Joe Lawton was a student in Stockport who drove his father's car following a party, was arrested for drink driving, got a letter and shot himself. At the side of his body was found the letter from the police. Keisha Leatherbarrow was in custody, and there was also, I haven't got time to go into all the details here, but essentially she could not be placed and was kept in police custody. And she was a young woman with very problematic background, very severe difficulties, but was kept in custody because she wasn't being treated as, if she was 15 or 16 year old, she would have been transferred to different accommodation. Okay. This case, HC, actually led to the changes in legislation or policy, and it shows the importance actually of viewing 17-year-olds as children. he was a young lad who was arrested on suspicion of robbery. He was attending college. The arrangements for attending college, he lived with his grandmother during the week, and he went to his mother's at the weekend. He asked for his mum to be informed. The police refused on the grounds that they might hinder the search for his property. If he lived with his mother, they would have to have informed her. She would have been, because of his if he'd been 16. Eventually, his mother became aware that he was in police custody, and she arranged for a lawyer and so on, and he was bailed, and then eventually the charges were dropped. Okay. This case went to court, and the whole argument is around whether underpaid 17-year-old should be treated as a child, in fact. The lawyers for the police and the Home Office said, well, this is a kind of argument only lawyers and clever people can put forward, clever people like lawyers. There's nothing in the code of practice that says a 17-year-old can't get special protection, but they would have to have another vulnerability, so they'd have to have a mental health problem or a learning disability. So it's not that 17-year-olds can't get special protection, it's just that they have to, which of course didn't apply in HC's case anyway. So that was dismissed as preposterous by Lord Justice Moses, actually. And this is the nub of the matter. The wish of a 17-year-old in trouble to seek the support of a parent, or of a parent to be available to give that help, must surely lie at the heart of family right. So, which is quite apart from Article 8 of the Human Rights Act, that the government seeks to maintain and encourage. So this is exactly what we'd expect parents to do. We'd expect them and want them to be concerned about their children. And actually this legislation, the failure to treat 17-year-olds in this way, was preventing this. I've got 5 minutes. So ACPO issued guidance, and now essentially under 18s are treated as juveniles in custody, or should be. There's another way that young people come into police custody that we need to consider here, which is around the use of the Mental Health Act. Mental health services generally, to use that euphemism, under a great deal of pressure, they're in crisis, they're chaos. And the general, austerity, cutbacks in youth services, all these things have an impact. They have a pinch point, and that comes in these sorts of areas. And these, as Barry was saying, are political decisions. Section 136 of the Mental Health Act is a police power, and it allows an officer to take a person to a place of safety. Now, normally, a place of safety should be a health facility, but it can be a police cell. In 2013-14, 753 children were detained under Section 136. So, 2 a day, in effect, which is worrying in itself. These are situations a police officer might use this power if, for example, somebody was on a motorway bridge threatening to jump. So it's people putting themselves at serious risk of self-harm and so on. And 236 of those children and young people were in a police cell. So we get back to what Carolyne was talking about, the nature of that cell. What is it? What sort of environment of the young people being detained in? The use of Section 136 varies incredibly across police forces, and the use of police cells varies. Devon and Cornwall come at the top of this list, is probably the wrong way of putting it, but they were used most. Whereas in Greater Manchester last year, Greater Manchester Police used police cells twice for juveniles. So, the government have decided the Home Affairs Select Committee have recommended that the use of police cells for children detained under Section 136 should stop, which leads you to think, well, if it's not safe, if it's not appropriate for a young person who's being detained on the grounds of their mental health, why is it an okay environment for someone who's facing a criminal charge? So there's a logic there that would lead us perhaps to Barry's abolitionist position. And if you look here, you'll see that the the Howling Penal Reform did some research and looked at the use of whether there's specialist services, special suite for children being detained under 136. Only 6 trusts out of 52 had specific services for young people. So the concerns here are about the safety, about the impact of these incidents or cases, however you want to phrase it, on the young people concerned. Certainly in the research I've done of the use of Section 136 for adults, and if you look at, there's very limited research on what the impact that is on individuals who've been subject to it. But one of the key themes that comes out is that people feel as though they've been arrested. They don't think because they have. The majority of us don't have a nuanced understanding of the difference between being arrested by the police and being detained under Section 136, and nor do our friends and family and so on. And that's what I'm going to say.
We are going to finish at 4:30. I'm going to make sure we finish at 4:30, which is what we've said. I'm going to start off the panel discussion and contribution from the floor by inviting Professor Neal Hazel to say a few words. Neal's a Professor of Criminology at the University of Salford and is involved in a project called Beyond Youth Custody.
I just wanted to say a couple of things. First of all, while the panel gets together. First of all, to read out a quote from a young person, a 15-year-old girl, about time in police custody, actually, to make a link between the panel and here in a research project I did. And for the social scientists who are here, who are sort of thinking the word power all the time, because when we're talking about vulnerability here, and when we're talking about the young person's position, what we're talking about really is a real power imbalance that's going on. That's not just about judicial power, but it's also about their position in the world as children as well. And I think that really comes through this quote. So I'm going to introduce you to this. It says, this is from this 15-year-old child. "There's no privacy in the police cell. When I go to sleep, I like to suck my thumb and twiddle my belly button. And when I'm in the cell, I always do, because it's like my comfort. And then the sniggers you get, the little sniggery and snidey comments all the time. As soon as your mum or whoever's with you is not around, not in earsight, that's when they start going on. And because you're a child, you say, 'Mum, that officer was really rude to me, he called me this, he called me that,' and your mum's not going to believe you. She'll say, 'You're just saying that, he's a police officer, he's not allowed to do that.' Not allowed. When's that ever stopped him?" And there's a real sense of sort of frustration and sort of the power imbalance that's going on there as a sort of a transition into the panel. Beyond Youth Custody is the project I'm working with at the moment, which is a resettlement project. It's on beyondyouthcustody.net if you want to look it up. And we produce regular updates looking at news and research in relation to youth custody up to 25, youth custody and resettlement. And there's two things I just wanted to start the panel by introducing there. I know we've heard a lot today, I say we, I haven't been here, but I've looked at the slides, a lot about young people who offend as children and treating them as children rather than as offenders. But even as offenders, it doesn't make sense. Even as putting them in custody, even if you've got the aim of lowering offending, it doesn't make sense. Now, my work has been mainly looking at resettlement, looking at what to do when children come out. And what you find is most of what we know works, most of what we know is effective, is about trying to deal with the problems that putting them in custody has caused you in the first place. So we know that effective resettlement is about starting early, getting their education right for when they come out. It's about, but that's because of the interruption that you've made, or about not getting that ETE sorted out while they're outside. It's about trying to mend family relations, trying to bring the family in for visits, about getting them released on temporary license, all those things that actually would be easier if they weren't in custody in the first place. It's about trying to smooth that transition when they first come out, because of the shock when they first come out, so things that actually you wouldn't have to deal with as well. The thing that Beyond Youth Custody has added to this debate, this whole list of things that we know are important for resettlement, is that it's put it within a desistance framework. It's recognised that actually what this is about, resettlement, is a journey where you try to shift the young person's personal narrative, the way they see themselves, from criminal to constructive member of society, or just a child in a more positive sense. The reason why that's so important, why that shift and to recognise resettlement within that desistance journey is so important, is because then you appreciate that actually putting them into custody, even in terms of offending, is a backward step, because there's nothing that's going to make them think of themselves less as like an ordinary child, a normal child, a positive constructive child, than making them a convict. That's what reinforces those negative perceptions, that actually gets in the way of desistance. So that's where I wanted to come and add to this from the resettlement perspective. Even if you look at them as offenders, it still doesn't make sense.